Legal drama with lasers. Attention Earthlings, lobbyists, and future Martian notaries. Welcome to Space Law Wars, the coming fight for orbit ownership. Today we'll litigate again, and then tweet about the verdict. Bring your gavels, your staplers, and a snack, because outer space is about to get more complicated than your Wi-Fi password. Who owns the sky? Spoiler, nobody, kind of. Imagine a neighborhood where everyone built tree houses at different heights, and then tried to sell rooftop parking spots. That's low Earth orbit. The problem? The HOA rules were written by 1960s diplomats in suits who had no idea about startups, swarms of CubeSats, or billionaire garage sale budgets. So now we're stuck arguing over who owns which sliver of the sky, who gets the orbital driveway, and what happens when someone leaves a toaster up there and it starts a chain reaction. Origin story of space law. The 1960s did the best they could. The Outer Space Treaty of 1967. Basically, no national appropriation. Space is the province of all humankind. Translated, don't plant flags and claim Disney World. It was noble, diplomatic, and written before smartphone. Good intentions, terrible for 21st century startups. Then came liability frameworks, rescue agreements, and a ton of legal footnotes that sound like they were drafted by someone who sleeps with a copy of the UN Charter under their pillow. Fast forward. New players, new problems. Enter private companies, mega constellations, and nations with agendas. Suddenly orbit is crowded. The radio spectrum is hogged like a radio at a family reunion, and countries want shiny flags on shiny things. Companies want to mine asteroids, sell bandwidth, and name orbital slots after their brands. The treaties didn't mention influencer tie-ins, so lawyers are improvising. Expect lawsuits, interpretive dance, and a very polite but very aggressive arbitration. Orbit slots and spectrum, the great space ticket rush. Radio frequencies and orbital slots are basically the VIP parking of space. The ITU and national regulators hand out spectrum like permission slips, and every satellite operator wants a slice of the best sky. If you thought airport landing slots were competitive, imagine Kelly Clarkson screaming, "Because of you," as two satellites try to occupy the same visible arc. Spoiler, those collisions are not a duet. The garbage problem that keeps on giving. Space debris is like that friend who never returns your hoodie. Annoying, persistent, and likely to trigger a fight. Hit enough junk and you trigger Kessler syndrome. A chain reaction that turns orbit into a cosmic pinball machine. Who's liable for the flying soup of metal? Old treaties say nations are responsible for their objects. But when satellites belong to private firms, expect finger-pointing worthy of a reality show reunion. Asteroid mining. Own or rent, and who gets the ore? Asteroid mining is the part where sci-fi meets HOA disputes. Some countries passed laws letting companies own extracted resources. Basically, finders, keepers for space rock. Critics say this violates the no appropriation principle. Supporters say it's economic incentive. Translation? Imagine two neighbors fighting over a meteorite in the backyard because one brought a shovel and the other brought a contract signed by a lawyer. Salvage, piracy, and space cops. Kind of. Who enforces space law? There's no intergalactic police department yet, so enforcement is messy. Sanctions, radio bans, or lawsuits filed in Earth courts. Salvage law raises wild questions. If you rescue a derelict satellite, do you get to sell it, or does its country of registry cry into the legal briefs? Add the threat of space pirates, mostly in press releases at the moment, and you get a legal drama with more plot twists than a soap opera. Liability and insurance, the unglamorous but crucial stuff. Who pays when things go boom? Liability rules say launching states are on the hook, which is great until a launch involves multiple contractors and a chain of subcontractors and a coffee vendor. Insurance markets are adjusting, premiums rise, and underwriters practice deep breathing. Expect indemnity clauses within indemnity clauses, and an entire cottage industry of lawyers who love clauses. Space traffic management. Who gets the right of way? With thousands of satellites launching, there's a growing need for space traffic rules. Like driving, but with more vacuum and fewer seatbelts. Who yields? Do bigger satellites have right of way? Can one operator force another to move? Proposals include traffic coordination centers, data sharing, and maybe some very civil mediations. Or we could just rely on goodwill and keep playing orbital bumper cars until someone files for arbitration. Privatization versus common good. Whose future is it anyway? This debate boils down to, is space a commons or a marketplace? Public interest advocates want open science and shared benefits. Corporate interests want property rights, monetization, and naming rights. It's basically a legal tug-of-war where the rope is made of treaties and the referee is an international committee that speaks in very formal tone. Power plays, nations, corporations, and alliances. Expect coalition building. Some nations will ally with companies for economic benefits. Others will demand strict controls. Trade deals may soon include orbital clauses. Picture diplomats sipping tea while negotiating who gets which pole-to-pole comms corridor like it's a parking space in a crowded mall. It's geopolitics with more telescope. The future, possible resolutions, and the most likely absurdities. Solutions could include updated treaties, orbital cadasters, yes, a land registry in space, binding norms for debris mitigation, and licensing systems for asteroid extraction. Or we could embrace chaos, let the market sort it out, and later fund a multinational cleanup initiative while the lawyers argue over the receipts. Either way, expect lots of memos, a few heroic court rulings, and a best-selling book called How I Arbitered the Sky. Who wins? No, really. Who wins space law wars? Humanity, if we're smart, because sane rules prevent orbital anarchy and keep satellites doing their day jobs. Corporations win if they secure stable property/contract frameworks. Nations win if they protect sovereignty and influence, but the real victor will be whoever writes the first enforceable, widely accepted rule that keeps the sky usable and the lawyers slightly less smug. If you found this scandalous, outrageous, or mildly terrifying, hit like, subscribe, and drop your verdict. Should space be a shared commons or a mega market? Debate in the comments and bring receipts, citations, and preferably a legal pad. This has been Space Law Wars, the coming fight for orbit ownership. Tune in next time when we determine whether cosmic property lines can be surveyed with a drone or a very determined intern. Good night, planet. Try not to start any litigation while asleep.